Okay, let's get right into it. Picture this. Nancy has been brought to the hospital after a small fire at her house.
Okay.
She's struggling with sleep, lost interest in everything, and the doctors are genuinely concerned about her well-being, maybe even her safety.
Right. Serious concerns.
Yet, despite their worries, Nancy is refusing any treatment.
Hmm.
And this instantly throws a spotlight on an incredibly challenging question. When and under what circumstances should someone be compelled to receive mental health interventions against their will?
Nancy's situation, yeah, it perfectly sets the stage for what we're analyzing today. Our focus is on the complex legal landscape of compulsory mental health interventions.
Right.
And we'll be using the tools of, legal analysis, critical thinking, and logic to really dissect the core issues at play here.
Exactly. For you, our listener who wants to quickly and thoroughly understand complicated issues and experience those aha moments without feeling overwhelmed, well, that's precisely what we aim to deliver as we navigate this pretty dense legal terrain.
Our primary source for this deep dive is Anna Nilsson's insightful work, Compulsory Mental Health Interventions and the CRPD Minding Equality.
Mm-hmm.
This book provides a meticulous legal and ethical examination of this very challenging area of law. And just to clarify for everyone, CRPD refers to the UN Convention on the Rights of Persons with Disabilities.
Right, which is central to this whole conversation.
Absolutely.
And our goal today is to extract the fundamental legal arguments and frameworks used to analyze these compulsory interventions. We're really going to focus on that inherent tension
Yeah, the conflict.
between an individual's fundamental rights, like their liberty, personal integrity, the right to make their own decisions, and the state's duty to protect health and life, exactly as Nielsen breaks it down in her analysis.
And the core of this debate, it really stems from a fundamental disagreement.
Mm-hmm.
You've got the CRPD committee asserting that compulsory mental health care inherently violates the prohibition against discrimination. They point to the fact that its effectiveness isn't always proven, and that it can cause significant pain and trauma.
So their argument is basically that singling people out based on a disability is discriminatory.
Pretty much. They argue it's arbitrary, especially just based on a diagnosis, and they advocate for abolishing these laws. Relying just on a diagnosis to take away liberty, that's the problematic part for them.
But then, as Nielsen points out, most states see it differently.
Right. The vast majority hold that sometimes compulsory intervention is a necessary last resort, to protect the individual's health or life, or maybe to prevent harm to others.
Provided there are safeguards, legal safeguards.
Exactly. With the correct legal safeguards in place, they argue it can be lawful. And this wasn't just a recent thing. This difference was there right from the CRPD drafting stage.
Ah, interesting.
And the dialogue, or perhaps tension, continues between the committee and the states.
So from a legal analysis perspective, the whole thing kind of hinges on how we understand equality and non-discrimination.
That's the crux of it, especially what on an equal basis with others really means. The CRPD's fundamental aim is clear. Make sure people with disabilities are seen as rights holders and can enjoy all human rights equally.
And Nielsen notes that even though they disagreed on compulsory care itself during the negotiations,
They did agree on that core principle of equal enjoyment of rights.
right, but that phrase, on an equal basis with others, it became a bit of a sticking point in interpretation.
Very much so. Some states saw it as simply meaning no extra rights, while others saw it demanding a fundamental shift in respecting their rights.
So the interpretation has huge legal implications.
Absolutely massive. And this is where Nielsen introduces proportionality reasoning.
Okay, proportionality.
Yeah, as a crucial analytical framework. It helps assess whether any discrimination, like maybe in these compulsory care laws, can be considered reasonable under human rights law. It gives a structured, logical way to weigh up the arguments for and against a system.
Okay, so let's dive into that. Proportionality reasoning. It's about weighing arguments, but how does it actually work, legally speaking?
Well, as Nielsen explains it through that legal lens, it uses key criteria, notably this objective and reasonable standard,
Objective and reasonable. Got it.
which involves asking, does the law pursue a legitimate aim? Does it actually help achieve that aim? And, crucially, is it reasonable when you look at the aim?
So it forces justification.
Exactly. Any law that differentiates between groups or even just impacts one group more heavily has to be rigorously justified. You need logic, you need evidence.
So from that legal perspective, what are the usual legitimate aims claimed for compulsory interventions?
Legally, they usually boil down to protecting the health and life of the person involved, or protecting third parties from harm.
Makes sense.
And Nielsen's analysis confirms these generally do align with the CRPD's purpose and rights, but she stresses a critical legal distinction.
Which is?
The difference between those legitimate aims and the coercive means you use to get there.
Right, the why versus the how.
Precisely. And interestingly, the CRPD committee interprets Article 10, the right to life, as including suicide prevention too.
Okay, so the why might align with rights, but the how, the coercion, that's where the legal and ethical mud gets really thick.
Exactly.
So analytically, does this coercive care actually work? Does it achieve those legitimate aims? Let's take protecting health first.
Yeah, and this is where the legal analysis gets really nuanced. Nielsen explores just how complex and uncertain the effectiveness data is. Legal arguments often cite studies suggesting, well, limited long-term improvements. And the legal literature also points to potential downsides, like emotional harm or people being less satisfied with their care.
So things like being admitted involuntarily multiple times could actually make things worse in terms of satisfaction.
That's what some studies suggest, legally linked to lower satisfaction rates. So the justification based just on health protection isn't always a slam dunk legally.
That definitely raises legal questions about how justified it is. What about protecting life, preventing suicide from a legal and logical angle?
Legally, the common view accepts that clinical treatment, say for severe depression, is key for suicide prevention.
Right.
And you can argue hospitalization is needed to make that treatment happen and, temporarily stop someone harming themselves.
Right.
But Nielsen's legal analysis questions the justification for keeping someone hospitalized long-term if the treatment isn't actually working and the suicidal thoughts persist.
So temporary safety, maybe, but if the treatment goal isn't met, the legal basis weakens.
It becomes less convincing, yeah. The initial aim isn't being achieved.
And the third aim, protecting others. We hear dangerousness a lot in legal talk. How does that fit in?
Well, legally, the idea has shifted a bit from seeing dangerousness as a fixed thing.
Like someone is dangerous.
Right, to assessing risk, which theoretically puts everyone on a spectrum. But in practice, psychiatric risk assessments are still used to flag individuals thought to be at high risk.
But how good are those assessments, legally speaking?
That's the problem. Nielsen's legal analysis highlights their limitations. Studies show challenges with both sensitivity correctly picking those who will offend and specificity correctly picking those who won't.
So they're not foolproof.
Far from it. And these limitations raise big legal questions about how objective and therefore legally defensible coercive care based only on predicted risk really is. Relying solely on these tools to justify taking away liberty is inherently tricky due to their unreliability.
Okay, so based on all this legal and logical analysis, is just using a psychiatric diagnosis or the label of disability enough to justify coercion legally?
Nielsen directly challenges that legally. She questions if disability or a diagnosis by itself is an objective and reasonable legal basis.
Because the act of imposing care itself causes harm.
Exactly. The very act of forcing hospitalization, forcing medication instead of it being chosen, often leads to emotional harm, distress, that raises legal flags about proportionality.
And people report quite severe impacts.
Yeah, Nielsen references a systematic review highlighting experiences of physical and emotional pain, feeling degraded, humiliated, even terrified. These aren't trivial consequences from a human rights law standpoint.
And the legal burden isn't just that immediate emotional hit, right? The system design matters too.
Absolutely. The legal design of these mental health regimes heavily influences how much they burden individual rights. Laws allowing long-term detention in really restrictive places. That's a massive infringement on liberty, legally speaking.
Compared to, say, shorter time frames or less coercion.
Right. Or laws that restrict particularly painful or intrusive treatments raise more serious legal and ethical alarms. And how much say the individual legally has in their treatment is crucial.
So laws that respect the right to refuse treatment if you have capacity are less problematic legally.
Much less so than those giving the doctor the final say regardless. And Nielsen's analysis also suggests laws written in generic, disability-neutral terms.
Meaning they apply to everyone in a certain situation, not just people with specific disabilities.
Exactly. Those are more likely to be seen as legally reasonable and non-discriminatory than laws targeting specific groups. Think about it. A weekend hold where you can see family is legally a very different infringement than months locked away with forced meds.
So it's this incredibly delicate legal balancing act. You've got the potential benefits protection versus these really significant negative impacts on rights and freedoms.
Spot on.
And Nilsson brings in Alexi's model of proportionality assessment as a tool for this legal reasoning. Okay, walk us through the basics of that legally.
Alexi's model gives a structured, step-by-step legal process. First, identify a legitimate aim.
Okay,
Then examine the suitability. Does the measure actually help achieve the aim?
right.
Then necessity, are there less restrictive ways to do it?
The alternatives.
Yes. And finally, the balancing stage,
Right.
where the legal reasons for and against are carefully weighed up.
Let's take suitability. How might that apply legally to coercive care?
Nilsson's legal analysis uses a great example. A system that automatically stops anyone from refusing medication might be legally unsuitable, too broad, if most patients actually can make informed decisions.
Because research suggests many can.
Exactly. As she mentioned, legal research indicates many people admitted involuntarily do have that capacity. So, like in Nancy's case, if she's refusing but understands the risks and benefits, is a blanket policy forcing meds suitable in this legal framework? Probably not.
Makes logical sense legally. What about necessity? That seems vital when you're restricting fundamental rights. Are there genuinely no less coercive options, legally and practically?
Necessity legally demands we really look hard at less restrictive alternatives that could achieve the same goal. Nelson's analysis mentions things like soteria houses, open dialogue,
Family group conferencing, advocates.
ombudsmen, community crisis care, yeah. These try to support people without coercion, or with minimal coercion.
Oh.
But her analysis also notes that while they're promising, the definitive legal and empirical proof of their effectiveness across all situations is still a bit limited. Methodological issues in the studies,
Right. So after establishing aim, suitability, and necessity legally, we hit the balancing stage. How does Alexi's model help with that really tricky part of legal reasoning?
Alexi offers the weight formula as a structured legal approach to balancing. It involves looking at the abstract legal weights of the competing rights or interests, call them we and WA.
Okay, abstract weights.
Then the degrees of infringement on those rights, 2 and IA, and importantly, the reliability of our assumptions about those infringements, RE and RJ.
Abstract weights. What does that legally mean here? Like, how important is the right itself?
Pretty much. It's the inherent importance the law, like the CRPD or General Human Rights Law, gives to that right or interest, regardless of the specific case facts. Think personal liberty versus the state's interest in preventing suicide.
Can you actually put a number on that weight?
Well, assigning precise numbers is debated in legal scholarship. But Nilsson notes some rights, like the absolute ban on torture, have a very, very high, almost absolute, abstract legal weight.
Okay. And the degrees of infringement. How do we legally measure how much a right is being interfered with?
You assess that legally for each right separately. For personal liberty, relevant legal factors are things like, what are the legal grounds for detention? How long can it legally last? How restrictive is the place? Does the person still legally get to make informed choices about treatment?
So indefinite solitary confinement is a way bigger legal infringement than a short voluntary stay with choices.
Absolutely. A massive legal difference. And Nilsson's analysis stresses that the CRPD put such a strong focus on self-determination that overriding the wishes of someone legally capable of deciding, that's seen as a more severe legal infringement. Think of it legally. Depriving liberty without proper process for ages infringes more than a temporary legally sound restriction.
And finally, reliability of assumptions. That sounds crucial given all the uncertainty we talked about earlier.
Exactly. This legally acknowledges that epistemic uncertainty. We might have legal and medical data on suicide rates in hospitals, perhaps, but maybe less solid legal and empirical evidence on how well specific treatments work long-term, or how someone will feel about their compulsory admission looking back.
So how reliable the evidence is affects the legal weight you can give it.
Significantly. It impacts how much legal weight we can justifiably attach to our assessments of how much rights are being infringed.
Now let's loop this legal analysis back to the core issue, non-discrimination. How does proportionality fit with that fundamental human rights law principle?
Nilsson's legal analysis really emphasizes that in the non-discrimination context, proportionality zeroes in on the comparative disadvantage between different groups under the law.
Comparing groups.
Yes. She talks about a coherence stage. The idea is that legal policies that look reasonable on their own might actually be discriminatory when you compare them to how similar legal situations are handled for other groups.
Can you give an example?
Sure. If we legally justify compulsory intervention for suicide risk in people with psychosocial disabilities based on, say, the value of life, logic demands we ask,
Hmm.
would we apply the same legal reasoning and intervention to someone without that disability who's at a similar risk level and has similar decision-making capacity?
That consistency requirement, that sounds like a cornerstone for a fair, non-discriminatory legal system. Can you give more legal examples of how that plays out?
Okay, but take compulsory intervention to protect health. Consistency means if a legally defined lack of decision-making ability justifies forcing treatment on someone with a psychosocial condition, that same legal standard must generally apply to anyone else lacking that specific capacity, whatever the reason.
So it challenges laws that take away the right to refuse treatment from someone with a psychosocial disability, even if they can actually make the decision legally.
Precisely. It directly challenges that. Or think about civil detention to prevent suicide. It's legally tough to justify intervening based only on a depression diagnosis if you wouldn't legally step in for someone with, say, severe physical pain from a different condition that also heavily influences their preferences, assuming they have similar decision-making capacity.
And for protecting others.
Same legal logic. Justifying different treatment based on predicting future violence becomes legally very difficult if similar risk assessments and interventions aren't considered for other groups showing comparable risk factors, but who don't have the protected characteristic of a psychosocial disability.
So fundamentally, it's applying the same legal rules and justifications across the board to ensure equality before the law. What about the specific harms of discrimination itself? How do they legally fit into the proportionality balancing?
Nilsson's legal analysis argues strongly that these equality-specific harms, things like socioeconomic disadvantage, marginalization, stigma, violence, which disproportionately hit groups like persons with psychosocial disabilities, have to be explicitly and seriously weighed in the balancing stage.
So the fact that these harms already exist makes the legal case against potentially discriminatory interventions even stronger.
Exactly. It strengthens the legal argument for finding a non-discrimination violation because it highlights the wider context of systemic inequality that these interventions might just make worse or continue.
Okay, let's think about some hypothetical legal setups. What might a CRPD compliant system look like, focusing on the legally okay aims of protecting health and lives?
Well, Nilsson's analysis suggests the CRPD, read consistently, does allow for some very strictly defined compulsory care, but only as an absolute last resort, and only when you genuinely can't get a free and informed decision, even with lots of support.
And the key is consistency in applying the legal standard for capacity.
That's the crucial legal element. If compulsory care is legally okay for serious health issues in one group lacking the defined legal capacity, the same legal criteria and procedures have to apply to everyone else in clearly similar situations, regardless of disability.
What about suicide prevention? Can you legally focus interventions there?
Potentially. A very carefully tailored legal framework might, as a temporary last resort, allow focused intervention for individuals with specific psychosocial conditions shown to be at significantly higher risk.
Big caveats.
Huge ones. It would need rock-solid, evidence-based justification and regular independent legal review to stop it becoming discriminatory in practice. The main legal aim, wherever possible, should be disability-neutral laws on capacity and consent. That's the path to genuinely equal treatment legally.
Okay, so let's bring it all back to Nancy, where we started, with this deeper legal understanding, these analytical frameworks. How should we approach her refusal of treatment now, given the doctor's concerns?
Now, looking at Nancy through this legal lens, key questions jump out. First, what's the legal assessment of her actual capacity? Can she make a free, informed decision about her treatment right now?
That seems fundamental.
It is. Second, based on these frameworks, what are the potential legal justifications, both for and against intervening against her will in her specific circumstances? We have to legally weigh her fundamental right to refuse treatment against the state's recognized legal interest in protecting her well-being, maybe preventing suicide.
All while sticking rigidly to those legal principles of equality and non-discrimination.
Absolutely, no shortcuts there.
So the core legal takeaways from our deep dive today are really This inherent tension, legally recognized between individual rights and state interests, the absolute bedrock importance of equality and non-discrimination as legal principles, and the power of proportionality reasoning, Alexi's model, the objective and reasonable standard as an analytical tool.
Right.
And that consistency requirement really feels like a linchpin for any non-discriminatory legal approach.
Precisely. And we've also highlighted the legal importance of actively considering those equality-specific harms that discriminatory legal practices can cause or worsen. Look, navigating compulsory mental health interventions is an incredibly complex legal and ethical maze.
No easy answers.
None at all. It demands rigorous legal analysis, critical thinking rooted in human rights law, and a constant commitment to both protecting vulnerable people and upholding their fundamental legal rights.
This definitely provides a solid legal framework for thinking about these tough issues. And for you, our listener, we really encourage you to maybe delve deeper into Nilsson's work, think critically about how these legal principles play out in real-world mental health law and policy debates.
Yeah, it's vital stuff.
And here's a final provocative legal thought for you to chew on. Given how inherently difficult it is to strike that just legal balance between liberty and protecting life, what specific legal safeguards are the most crucial ones to have in any system that permits compulsory interventions as a last resort? And maybe even harder, how can we effectively ensure those safeguards are actually implemented and independently monitored to prevent discrimination and abuse within the legal system itself?